we have before us Nate Jackson, Chairman, Commissioner Norton, Commissioner Gavin, Chairman Roberts, John Roberts at that. Let me correct that one. We had Farrah somewhere, but she's disappeared. We had Commissioner Kramer, Commissioner Levy, and we have the staff. Acting Director Jason Gilliam. Just Jason, okay. And we have our two general counsel, Huffman and Smith, and is that Chris? Reed and...
Oh, sorry, I'm the program attorney, Maria Bush.
Okay, well, since everybody's here, we can get started. Counsel Huffman or either Counsel Smith, whichever one, we can get started.
So this is the legal committee meeting. We're going to go through the legal report, and of course we're here to answer any questions you have on each or any of the complaints that are listed.
We got some questions on some of them. I guess, do you have them before 38 or?
You can take 38 if you like.
All right. Number 38, 2090458. Let me find. It's dealing with a manufacturer and a dealer. And I guess my question is, recommendation was to put it in monitoring status. Can you share with me to a degree what are we talking about here?
Well, this is a very big case, and actually what we want to do is put in monitoring status so that we can send out some investigators to understand what's going on with this case and also to see if there are any violations.
Normally in a case like this, it should come before us, but if you're sending your investigators out to determine the information to bring it, if you're thinking it need to be brought, okay.
Right, and both parties have been sending a lot of information to us, and a lot of, it's very
complex.
Voluminous, yes. I mean, it's complex, and we want to make sure we get it right, so we're going to be sending out investigators, and that's why we want to put it in monitoring status.
Can we state that on the record that you're going to actually investigate further?
Yes.
Yeah. Good deal.
Yeah, that was an unusual one. It looks like it looks like it was headed to something like a formal hearing or something. But okay, case number 53. Just a small question on this one. It's about a business was closing. A cousin sold a car. It was unsure to who sold the car, so there was it wasn't unclear who sold the car. It was unclear who was responsible for the sale of the car, and there was a $500 unlicensed activity penalty. And my question is, who was the penalty for, the respondent or the cousin? Just
the respondent.
Okay.
Allowing the cousin to sell.
Well, that's the part. I mean, it didn't say for sure who it was, and the respondent had no knowledge of the sale or activity of any sales. But I'm assuming he's still responsible since it was his lot.
Exactly.
Gotcha. Okay. 108.
Oh, sorry. I was going to ask while you were looking. Go ahead. You got.
Go ahead.
It'll be in nice order. 82, 2019 009271. Insurance, whether it was clearly disclosed or not disclosed.
Yep, that is mine.
Okay. I understand the recommendation of the $5,000 penalty, and there definitely seemed to be something amiss with the deal paperwork. Is there anything just in the paperwork that would justify the penalty, or is it just the circumstantial evidence of it that's leading to the penalty?
You mean like is there physical evidence? There's document.
I guess what I'm asking is,
are you asking why it's so high?
Is there an actual violation just by the existence of the inconsistent paperwork that's leading to the penalty, or is it the speculation as to what they were actually doing in trying to hide this charge that's leading to the penalty?
Well, I mean, I just felt that the
investigative findings showed a false, fraudulent, and deceptive acts, which is a violation in and of itself, and I thought this was the worst of the kind, which is why I recommended 5,000. Does that answer the question, or?
And the specific fraudulent act being hiding the charging of the insurance?
Yes.
Okay.
And the investigator, I relied heavily on the investigator's findings because they do have a lot of experience out in the field, and they spoke directly to how serious of a violation it was. So I took their word for it as well. If that helps.
Thank you.
Okay, I had number 108. The inspector noticed violations from the same thing over and over, and there was a $3,000 civil penalty issued. And my question would be, for the commission, would be the follow-up for inspection. Is there, and what is the plan going forward on this dealer? Because he's clearly a bad actor.
I didn't recommend a follow-up, but I can definitely add a follow-up inspection in 30 days, 45 days, 60 days, whatever the commission feels is acceptable, in addition to the penalty.
This clearly is a. I mean, you got a $3,000 civil penalty, and to the previous case we just discussed, we had a $5,000 penalty for some, that wasn't very clear. So our intent would be, if we have a bad dealer that's doing the same thing over and over, I'm not sure why he still has a license to operate. So
I mean, we can discuss
Well,
a heavier.
it's not the fine. It's just like, I think obviously this guy, this dealer doesn't respond to anything. He just pays the fine and moves on into the next fine. So my question is, if he's going to keep doing what he's doing, what are we going to do as a commission to protect the consumers from being exposed to this kind of dealer?
Definitely, I think by re-inspecting,
Okay.
we can protect the consumers. I did up the penalty because it was a recurring violation. Normally, it wouldn't be so high, but I think re-inspection is definitely necessary. So,
Well, my question would any of us recommend one of our friends or family to go buy a car from this guy or this person, this dealer? No.
I think
not at all.
if after re-inspection, then we need to talk about taking away a license if there's more violations.
Agreed.
Absolutely.
So, agreed. So I'm saying we need a monitoring on this situation to see if we have compliance.
One second. Can we leave it open? And then after the inspection, we bring it back? So I can amend the recommendation to a $3,000 civil penalty and a re-inspection in 30 days. And we'll leave it open in a
All of it,
monitoring
yes.
status, and then we can bring it back.
You rather do it in 60 or 90 days so he wouldn't clean up his act short term?
Well, the inspection, when was that? The inspection was back in July,
Okay.
so that's why I was thinking,
Okay.
it's the only
That-
reason, the
that-
quicker,
Sure.
I'd do it in 10 days, but I figured we should give it 30.
Sure.
So, if that's acceptable.
I agree. I think it would be, since it's issued in July. Yeah, that gives enough time to spots to resume on that leopard. Okay.
Jim, will you finish
I've
the
got a
commission?
observation on case 11, or number 11. I thought this was pretty interesting, a complaint, a resident of California who paid over $1,000 of work done to their motorhome to include a $60.75 for shop supplies. And then the complainant told the reason why shop supplies was a percentage of electricity and like, which doesn't make any sense. I'm just wondering how many other incidents are they getting away with shop supplies, because shop supplies is sort of like a processing fee. It's just money to the dealer. But how he worded this is completely wrong.
After reading this complaint, I felt that the complainant probably worded it wrong in the complaint. I don't think that the respondent specifically said that, because I was sufficiently, I was happy with the way the respondent explained it as he explained it to the complainant after the complaint came in. I felt that everything was made sense of to the complainant. So I didn't send any kind of investigator out, so I don't really have any more details on it. I don't have any piece of paper that says those words, but we've never had a complaint about this before on this person or this dealer of anything of the sort.
Doesn't everybody have shop supply charges? But they cap them at a number?
Yes.
Yeah.
You have shop
Much
supply
less than
charges,
this.
but if a customer asks what shop supplies is, how many different answers are you going to get?
Right,
And
right.
this answer right here was just way off the wall. I mean, it's,
I mean, it was really very much an allegation that the complainant said, well, yeah, the shop supplies were electricity and so forth and so forth. I don't think there was a refund at all. I think there was a miscommunication that was resolved with better communication after the complaint was filed. Oh, I'm sorry. Oh, yes, no, I'm sorry, yes, you're right. The refund was the full amount. Yes.
Case number 119, just as a conversation, there's a couple of cases where there was a letter of warning concerning late delivery, and there were no timelines. And specific to both of these, I guess a title has to be issued within the timeline of, I guess, 30 days after a deal is funded. So I just didn't know if there was no clarity in a couple of cases about timelines on why there was an issue. A letter of warning issued on something under the timelines of acceptability, and I just bring it up using this 119 as an example. I didn't know if there's some not understanding of what the law says, or if there was something I missed on this particular case. Nothing paramount, just an observation.
Yeah, in some of these cases, I mean, the complainants are complaining about other things, and they don't really complain about their tags. I mean, and so we look at it and say, well, there was an issue there, and we want to send a letter warning for the issue of tags late. But sometimes when they're doing temporary tags of 3 or 4 temporary tags, of course we're going to do something about that. But sometimes the complainants get off on a complaint about everything else, and then we just kind of see that issue there, and that was kind of this case. But everything worked out with this complaint and the complainant.
Well, like in case number 122, there was a letter of warning for late delivery of title, and there was actually no timeline on that one. So I just didn't know if it was just something new. I had never noticed a warning for a late title, and with it falling in the timelines of acceptability. So.
Also, sometimes it's not the respondent's fault. There could be an issue with the auction, or there could be an issue with something else that,
Well, I noticed that in a couple
lost
other.
titles.
I noticed that in a couple other cases. Being a dealer, I understand there's no excuse for not providing the title, regardless whose fault it is, the dealers or the auctions. So there's just some discrepancy in understanding that. What I read as far as are there timelines? The timelines are the timelines, and you follow the letter of the law on that. It doesn't matter. I mean, I've been a dealer where I've had to refund money because the timeline of the auction didn't fit mine and the consumers. When I get to that second temporary tag, it doesn't matter. The auction caused the problem. I got to give that customer their money back. So that's all I'm saying. It's just making sure we're clear when we read these cases why there's warnings being issued, and if everybody understands the game.
Okay. And we'll make a note of that
Okay.
to make sure that we have timelines better spelled out for you.
One more. I guess it's more of my inexperience being on this commission, but like case 101, a lot of these dealers have gone out of business and they can't be reached. Is there any way for us to get more data so we could not let that be the case? I mean, I know they've got the surety bond posted here, and they can still get that. They've got access to that, but like an email address, forwarding addresses, do we require anything so we can find where they go?
Basically, we have what is on file, and that's what we look at. And these people, some of them will just not answer, or change their email, or they move around. So it's kind of tough sometimes to
Yeah, to your point, John, I see that I've read that a lot of these cases where the consumer is left in a situation where the dealer's gone and we've referred the surety bond, and that's basically all we're supposed to do as a commission.
Yes.
There is public information out there, but our job is to protect the consumer, and we feel like that we just leave them in a spot where there's a big disconnect between how they continue. That's it's on the consumer, but I understand.
We understand also.
I know you do.
Any more questions, concern about the legal report?
One other comment on 32. It's just mislead advertising. One on the Corvette LT1. I mean, this was a very interesting one. And then on the next page, talking about the 19 SS, and it wasn't. In both these cases, they have found no evidence of violation. I mean, to me, it's hard to believe that they didn't find any evidence. I mean, for false line and as misrepresentative. I mean, and I know they sent an inspector out there. It just doesn't make sense. We're starting to see more and more of this online, and I'm just wondering if you guys been seeing it yourselves, and are we going to start really cracking down on misleading advertising online?
I didn't feel, the complainant didn't even give us, I don't think the complainant gave us, the complainant had filed a complaint on the first one with the Corvette with the South Dakota, I guess the commission or board that does the same thing in that state that we do. And it did not go anywhere, and purposefully did not provide that file, which I thought was odd. Didn't provide the advertisement or any details about it, really. Just described in the complainant's own words why they thought it was misleading advertising, making it sound like it was this LT1 original. And I just felt like it was a very gray area, and because I didn't have the advertisement, I didn't have the exact words, and the way the respondent explained it seemed to me like it made sense that it could be miscommunicated if the complainant didn't come see the car, because the respondent basically begged him to come see the car, and he didn't. And so I just felt like that was on the consumer at that point, if you're not going to give me any more information. But I'm happy to hear suggestions on how, we can maybe look into it more or in a better way.
Well, let me ask you another question. You said an LT1 Corvette convertible, but then down below, the second paragraph, the complaint tells it is not a real L79. What's an L79 versus an LT1?
I don't know.
That doesn't make sense.
I don't
there.
know. I didn't, spend a whole lot of time trying to figure that out, because the complainant could have very easily provided that information and didn't, because the state of South Dakota closed it.
On the next page with the Camaro, the inspector says, well, come on down to see the vehicle. Well, that doesn't make sense, because he already bought the vehicle. He's already seen it, so why is he telling him to come down and see it? To me, it's just...
Sorry, I'm just going to look at this one for 1 second. Oh, he explained to the investigator that he encouraged the complainant to come see it before he bought it. In the second one, that's what I was trying to express. So we did do an investigation on that one, and there was just no. I rely on the investigators completely when I send them out. If they tell me there's no evidence, I don't really go any further with that one.
I'm just pointing out that we need to spend more time and closely, because we're going to see a lot more of this.
With the misleading advertising?
Yes, that is
okay,
correct.
Well, we can definitely be very diligent in making sure we get the exact advertisement, because I think in that first one, that was the problem for me. So we can do that going forward and be more diligent about that. And I know you had spoken last time about sending out sort of guidelines, putting the burden on the complainant, I think, or not the complainant, but the licensees. I think that's a good thing we can do. Stuart and I can continue talking about that.
Anyone else have any? Commissioner Levy, you have anything else?
less advertising this time.
Yeah,
More out of
these were her cases, so I didn't see them. So I would say that no, I have not. But and she would say yes, but I'm not saying there's a big influx of, or there's not. So there is or there's not. I don't know.
I would say I actually saw a lot of less advertising allegations of advertising violations this time around, but it kind of just comes in waves, honestly. I saw more out of state this time, but less advertising.
I'm glad, Commissioner Jackson, we're having this discussion because it's question that we just asked about certain cases that didn't make sense, but once we talked to the staff and they explained it, then it made sense. Yeah. With that said and done, any more comments? In case 38, we're going to continue to do some monitoring, and on that case, for more information, definitely on that one. And then 108, we're going to recommend a follow-up inspection and with a 30-day inspection. Other than that, let's adopt the report as read. Do I have a motion?
Motion.
Second. Any opposed? All in favor of the motion signify by saying aye.
Aye.
All opposed, ayes have it, so ordered. That's conclude our subject to the full commissioner recommendation.
Take a 5-minute break and we'll get started.
Adjourn.
Motion is second. All in favor to join, signify by saying aye.
Aye.
Ayes have it, so ordered.
Second, 2019 Tennessee Motor Vehicle Commission quarterly meeting, and it is now 9:06, and let's put that in the record that we got started. Jason Gillum is going to take Paula Shaw's spot. As most of you know, Paula has taken a better, a promotion, better, I guess, if you call it, getting more money, And so she went with the Department of Safety, and we all like Paula and appreciate what she did for us. But she's moved on, and Jason's going to help out today. Okay, you want to call roll?
Chairman Roberts,
Yes, here.
Chairman Lee, or Commissioner Lee,
Here.
Commissioner Galvin,
Here.
Commissioner West, Commissioner Fox,
Here.
Commissioner Kramer, Commissioner Jackson,
Here.
Commissioner Melton,
Here.
Commissioner Murray, Commissioner Norton,
Here.
Commissioner Vaughn,
Here.
Commissioner Tomaso,
Here.
Commissioner Levy,
Here.
Commissioner White,
Here.
Commissioner Evans,
Here.
Commissioner Barker,
Here.
Commissioner Chabanian.
Here.
Chairman, we have a quorum.
Everybody was sent the meeting notice. What's your pleasure on that?
Commissioner Jackson motion that we adopt the agenda.
Second?
Second.
Okay. Commissioner Barker seconded it. Any further discussion? All those in favor say aye.
Aye.
Opposed? What do we feel on the adopting the agenda? Is that it?
Yes, sir.
It's the same thing, that's right.
Yes, sir.
Meeting notice is the agenda, okay. We have the minutes from the July 23rd meeting. What's your pleasure on that? Haven't read it yet.
Second.
Any further discussion on the minutes? All those in favor say aye.
Aye.
Opposed? Minutes are approved. At this time, we would like to be addressed by Commissioner Lawrence. And Commissioner Lawrence, welcome.
Thank you, Chairman, for letting me come down and address you all today. Would normally let Toby take this, but Toby is actually at a training in Knoxville for the state. So I thought I would have the pleasure of coming down and talking to you. So as you all remember, there was a rule that you adopted to move forward, and it takes such a lengthy process that some of you might have forgotten, but basically the substantive things that it does is twofold. First is a requirement of email addresses, and then the second is about the physical separation of a facility, where the current rule calls for a hard wall. This rule would allow a little more flexibility to the business owner to allow a locked door in its place. So it's all very straightforward, supported by various members of the General Assembly. So we had no concerns about the rule being adopted for a positive recommendation from Joint GovOps. But one of the newish requirements from the Joint Government Operations Committee is that we answer some questions about the proposed rule that include the cost considerations with it, so what it would cost us to administer the rule. And as we were going through the process of answering that, we realized that we didn't have a good idea as to the email component, what that would cost us. So as we were trying to figure out, and we were getting closer to the deadline where we were going to have to appear in front of the committee, made the decision after internal discussion and talking with members of the General Assembly and then also staff for the committee that it would be in the best interest to press pause, which would officially and formally be done through a staying of the rules. So that is to happen either today or tomorrow. It's an official process that Maria was good enough to officially get started for us. So the reason we wanted to do that was to give a little more time in order for the Rule Committee to then pick up, again, the email question. And the formal process for starting that would be a bifurcation from you, the committee. That would allow you to bifurcate, to separate out the part that might need a little more consideration, a little more fact gathering, and to move forward then with the facility separation, since we know that's not controversial. There's a lot of support for it. So the proposed stay would be for 75 days, which we think would give enough time for, if it was the will of the commission, to press pause, to bifurcate, and then to move forward with the facility separation rule. So I wanted to see if you had any questions about what's happened so far, and then could talk about what would need to happen next.
Chairman, can I ask a quick question?
Yes.
This presentation doesn't appear to be on the agenda.
Yes.
Okay that we discuss it if it's not on the agenda.
What does legal think?
So I was going to speak to all of you an update on this rule under the legislative update, and that's kind of where it was. But Carter was kind enough to come earlier, so it's out of order, but it should be fine.
Properly covered.
Thank you.
Good question. Questions? Anything else?
And if any come up, please let us know, because so my request would be that you, the commission, would do a formal roll call vote to separate out the rule, to bifurcate, and then to move forward with the facility separation component, and then to send to the Rule Review Committee the other component of the rule. And Maria, any technical components that we need to talk about there?
No, just I would need a motion to withdraw the application portion of the rule, and I can read out the official number of that rule for the record, and then a roll call vote of the commission in order to have permission for me to file on behalf of, the commission this withdrawal.
Do so.
Okay. So this is going to be the rule regarding applications and emails, 0960-01-.08. And so if anyone would like to make that motion, that I, Maria Bush, have the authority to withdraw on behalf of the commission that portion of the rule.
Make a motion to give the staff authority to withdraw that number 5 on 0960-01-08.
Have a second? Second. Okay. Any further discussion?
I'd like to ask Jason to do a roll call vote, please.
Yes.
Thank you.
Jason, please do.
Commissioner Levy?
Yes.
Commissioner White?
Yes.
Chairman, question. So just for clarification, a yes is you want to move forward with the withdrawal, and a no is you do not?
Yes.
Okay, got it.
Commissioner Melton,
Yes.
Commissioner Chabanian,
Yes.
Commissioner Lee,
Yes.
Commissioner Barker,
Yes.
Commissioner Fox,
Yes.
Commissioner Galvin,
Yes.
Commissioner Norton,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Jackson,
Yes.
Commissioner Kramer,
Yes.
Commissioner Evans,
Yes.
Commissioner Tomaso,
Yes.
Chairman Roberts.
Yes.
Motion passes.
Maria, any other kind of technical back-end components we need to vote on?
Here, I'm ready, I think, to move forward on that, and then I can provide you all with an update at the January meeting.
Do we need another motion now to
Nope.
move forward?
We are good to go. Thank
Okay.
you.
How about for the rule committee to then pick back up the email provision? Do they need to formally address that?
No, I think we're good right now on that.
Okay, great. Well, if I could just say one other thing to kind of inform the discussion on the email component as you consider for that rule. So we have had enough time to kind of get some rough estimates for the cost. So we think we could actually do it as cheap as $3,750. So that is not a very significant. That might be a little bit lower. The high end, because they give massive ranges, was from $3,750 to $22,000. We will certainly hope that it is the lower end of that range and work for it to be that direction. I did, however, want to bring to your attention on the email question, because as many of you know, the governor has made rule issues a top priority. The General Assembly has broadly agreed that there is some concern that an email requirement could unfairly penalize our more rural licensees. That hasn't been entirely borne out with what we've witnessed through other programs that we have, where we see good email adoption, no matter what part of the state, whether urban or rural. But something for you to potentially consider would be how an email requirement might be received by the General Assembly, especially when taking light the good email uptick that you already have. So just 2 years ago, the Motor Vehicle Commission had very little initial online applications completed. Now it stands north of 80%. So in the 2 years, went from basically none to where the vast majority are doing it online. Online renewals have always been high and still remain north of 90%. So we feel really good about where about the technology uptick from your industry. Would have some concern about maybe mandating that for others to do it if they haven't picked it up on their own, to make them go do the email address, because we have right now the amount of people who are not using email addresses. I'm sorry, let me make that an affirmative. 51% of dealers have provided us an email address, and only 27% of salespeople. So there's a long ways to go for salespeople and for dealers. So this would be a change, and we would be making that affirmative requirement if you were to move forward with that rule. Whereas right now, we really don't have a problem with the technology usage. We've got really outstanding numbers from your industry. And I'll give big credit to Paula Shaw. And John, I have to say, I know you said she went to a better place. We feel pretty good about TDCI. She did get a good promotion. We're definitely happy for her. But Paula did a great job of pushing the industry for online adoption, and it's in a really strong place. So I would ask you to balance how strong you are right now with your online adoption against moving forward with an email requirement, with some of the currents that we're seeing from both the governor's administration and from the General Assembly about taking into consideration rural issues and whether that would potentially burden our more rural licensees.
Commissioner Lawrence, have y'all really studied anything else that we would need to add besides email? Because if you're going to go that much expense and trouble, is there anything else that we need that would help us, be able to communicate with the dealers?
Right. I think if it's okay to maybe have let us have an internal discussion about what might help with the best way to rapidly communicate with our licensees, because that's the goal, is that we want to be able to, without having to send snail mail, to be able to rapidly communicate. So If it's okay, if we could have an internal discussion about ways that we could accomplish that without making this affirmative requirement on the email, that could be both, a win-win in which we're not making that requirement that the General Assembly could balk at, while at the same time still allowing the administrative flexibility for us to be able to quickly get news out to the industry. So if we could, I think that'd be a good thing for Jason and Toby to talk about, and then to come back to y'all at your next meeting to address.
Are you good with that?
Just need to make sure that if this is adopted, that what about all the old email addresses as there's turnover? How would you manage that? Is that something you guys are also studying?
Yeah, so we wouldn't lose the current email addresses. So right now it's optional for people to provide their email address, and that's how it is for the vast majority of our other programs. And we would, I think it makes sense to keep it that way for now. But let us, if it's okay, have that conversation to see, because it might be that there could be a special reason why, for administration of this program, why the email addresses are really needed, and we have a strong argument to be able to take to the General Assembly and say, look, I know that there's generally a dislike for this imposition, but we think it's needed for us, and here's why. And we're happy to make that argument. If that's the administrative answer, we're happy to make that argument.
And just speaking as an OE rep, we communicate almost exclusively with our dealer body via email. That includes our sales consultants. Many of our programs are linked to an email address that we do incentives for them, training through them. So I don't understand the gap between our adoption with our dealers on email and the state's adoption for email. It should be a fairly easy thing to accomplish.
So we have really high online adoption. It's just that people haven't taken that next step of opting in via email.
That's right.
Also, there's to your point, there's 700 approximately franchise dealers in the state of Tennessee. There's over 3,000 independents. So there's a difference. This is how they manage their business. Yeah.
Commissioner, the email requirement, is it a company email or any email?
So this would be for each licensee, so that each licensee would have to have a unique email.
It's fine if it's a Gmail address, something like that.
Definitely.
Yeah.
Right.
Okay. Great. Thank you.
Thank you.
Great. Okay. So we will continue that discussion at your next meeting. Then. Thank you very much, Commissioners.
Okay, next we have salesperson and dealer appeals, and we've had one that contacted the commission prior to the meeting, and their sponsor couldn't show, so I guess we need a motion to put that one off. Is that what we would do? Till January. That's right. Carlos Fletcher Sr. Have I got that right? Okay. Do we have a motion to do so?
So moved.
Second.
Commissioner Vaughn, I think, won that motion. Second. Y'all got that recorded? Any further discussion? I guess we need to do a roll call vote.
Yes.
Commissioner Chibanian.
Yes.
Commissioner Lee.
Yes.
Commissioner Barker.
Yes.
Commissioner Fox.
Yes.
Commissioner Galvin.
Yes.
Commissioner Norton.
Yes.
Commissioner Vaughn.
Yes.
Commissioner Jackson.
Yes.
Commissioner Kramer.
Yes.
Commissioner Evans.
Yes.
Commissioner Tomaso.
Yes.
Chairman Roberts.
Yes.
Motion carries.
Okay, do we have James Rowland here today? Would you come up and address us, please?
Chairman Roberts, may I read an excerpt from legal on this?
Yes.
So, in the case of Mr. Dalton Schaefer, the documented conviction is for aggravated burglary.
No, wrong person.
Oh,
James
sorry.
Rowland.
James Rowland, I'm sorry. Dalton Schaefer's probably up next. Okay, in the case of Mr. James Rowland, the documented conviction is for money laundering on September 20th, 2007. From the documents received by the Commission, it appears that the applicant received a Class E felony on August 19th, 2011, and was ordered to 28 months of prison and 2 years of supervised probation. This application may be denied under TCA 551714A1C until December 19th, 2020.
Okay, Mr. Rowland, Did you bring anybody with you today? I did, sir. Did you like for him to come up at this time and you all both address us? You start first.
I'm James Rowan. Thanks each and every one of you for taking the time to listen to me. As you said, I had applied. I was partnerships in a dealership for many, many years, and we had zero problems throughout that time. I did have a time in my life where I run into a problem. I was charged, convicted of that crime, and did serve a sentence for it. I was relieved on probation and was granted early termination of my probation for that, and have had zero incidents at all before that and after that. And actually, the one with me today is my sponsor of the dealership that we sold the dealership that I had a few years back, my partner and I, and this is the dealership, the owner of the dealership that I'm looking to work for now.
All right, we'll wait just a moment to hear from him, but y'all have got questions for Mr. Rowland at this time?
I do. Could you expand upon what happened for the charges?
I apologize. I don't hear very well.
Could you expand upon what happened in this situation to
Yes, absolutely.
the charges to come about?
Where the charges come about, ma'am, I was charged with money laundering. I had a group of individuals that I had met and established somewhat of a friendship with, and I allowed them to pay me in cash, knowing that their money didn't come from ill gains. Is what I allowed them to do. I accepted money as payment that they did not earn legally. I was in no form or fashion involved with anything that they had done, but I did allow them to pay me with money that they made that was not made legally.
Question, Commissioner Norton. I mean, what do they pay you money for? Did they buy a car, or they just why were they paying you?
Yes, a few different things that they had done, but there was some vehicles. Two of the vehicles they purchased was not through a dealership, just vehicles that we had, and I think the other ones were through the dealership. But the problem was the ones actually purchased outside the dealership because they were above the monetary limits of accepting cash payment for it. I believe it's $10,000 and below. So the ones through my dealership, I believe, were low, but I did sell two outside of my dealership that personally titled in our personal name. It was not a untitled vehicle, but sold them, which was above the limits of that amount.
Any other questions from the commission?
Actually, I do have a few more questions. Were you required to make any form of restitution to?
There was no profit in anything that I had sold. I considered them friends, and I sold them for exactly what I had purchased the vehicles for.
As part of your agreement, were you required to pay back the state or any sort of entity?
I had no restitution and no fine, ma'am. Okay. There is a $100 fee that no matter what anyone, if you have a charge, I didn't really understand, but there's a $100 fee that everybody pays that if you go through an act like that, if you charge with anything, you have to pay that. But for as the judge, she didn't put on me restitution or any fines of that sort.
And this was the first time you were in trouble? Is that what you said earlier?
Yes, ma'am. I never had any previous trouble before that, and I take full responsibility for what I did. I wasn't raised that way. I was raised by a good Christian family. What I did is I let some people in my life that I'm not blaming them. I didn't have to accept the money. I've let some people in my life that normally I wouldn't allow in my life like that.
When was this again? 2007, is that what you said?
It originated in 2006 is when it started. I don't remember the date exactly when, but I know that I had a probation term, but shortly after I was put on probation, they allowed me, they not to finish it. I don't know how you would say that. I was released from probation early and didn't have to finish that.
How many transactions, roughly, and how much money in total?
Sorry.
How many transactions, how many vehicles did you sell? What was the total amount of money?
It was 5 vehicles over 5 years, if I remember right. And I think 3 of those was through an actual lot. But like I said, it doesn't change anything except there was no scheme. There was zero profit on my part. I did. It doesn't change what I did, but I do the same things I buy I bought some for people in our church and that we donate to people. If it's someone like that, I don't make a profit. I just do that. But it wasn't right. I mean,
let me understand something if I could. You sold 3 cars through the dealership, but you sold 2 personally, is that correct?
Yes, sir.
And the 2 you got in trouble for was the personal cars? Or
they had, I think, originally when they come in, they it's been many years ago, but I think there was a few charges, and one, I don't know which particular charge that they agreed on, but there was only one charge that they had. I'm sorry, I don't know which vehicle that would have been for.
The reason I ask, and this may be a question for our attorney, I know through a dealership you need to report any cash over $10,000, but does an individual have to do that also if it's an individual sale?
I believe so. I believe my attorney said I'm sorry, ma'am, go ahead.
They do?
I'm not sure off the top of my head, but I can look for you.
Oh, I didn't know that.
Mm-hmm. Okay.
The bank, they so any time there's a positive cash of $10,000 or more, they have to fill out a form. So I take it. It would be.
Any other questions? Let's hear from your sponsor at this time, and please tell us your name.
Yes, sir, board. Thank y'all. My name's Tony Campbell. I've been knowing James Rowland for over probably 20 years, and I'll be honest with you, I wouldn't be up here if I didn't believe in him. I know he made a mistake back years ago, but be honest with you, I don't really take cash at my car lot. I like money orders and checks, but if y'all could think of something to put him on probation for 1 year underneath me, I'll be responsible for it. If that's something y'all would agree to today. But he is a good guy, and he did make a mistake, but he has other state license before, and I'm in the bail bonding business also, and he was in that at one time. But I can guarantee you that, I think everybody deserves a second chance. But I'll be willing to take responsibility, put my license up. If he messes up, and I'm out. And I don't do that for nobody. I believe in him. I really do. Does anybody have any questions for me?
Commissioner, I have a question. Do you have, in your dealership, do you have an 8300 compliance program now?
I have what, sir?
8300 compliance for cash reporting. Do you have a compliance program?
Yes, sir. I'm actually have Frazier. Everything I do, I've actually encouraged other people. I don't know if y'all familiar with everybody calls me for a drive-out tag. So now it's all computerized. It goes straight to the Department of Revenue. And Frazier has a program. Any cash you take, it'll pop up that you have to fill out all that stuff. And that's, like I say, I mostly consider having money orders. Or I deal with certain banks, the SINs, and there's a bunch of them that I deal with. And they actually give me a money order, and then we really don't do cash. Very rare I do. If somebody makes a $200 payment, that's all I would have.
Thank you.
Further questions? Anything else from legal?
I would just like to note that I do not believe that we grant licenses like under probation status. So if you do vote to grant the license, it would have to be free and clear of any stipulations or anything attached to that. So that's up to the discretion of the commission. But
A motion on this appeal.
Commissioner Jackson, I motion that we grant his license.
And I second it.
Further discussion? Jason, would you call roll?
Commissioner Levy?
Yes.
Commissioner White?
Yes.
Commissioner Melton?
Yes.
Commissioner Chabanian?
Yes.
Commissioner Lee?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
No.
Commissioner Norton,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Jackson,
Yes.
Commissioner Kramer,
Yes.
Commissioner Evans,
Yes.
Commissioner Tomaso,
Yes.
Chairman Roberts.
Yes.
Motion passes.
Okay.
Thank y'all so much for y'all's time.
Thank you, sir. I appreciate you hearing me.
We have a Dalton Schaefer in the audience. Would you come up? You give us a briefing on this one?
In the case of Mr. Dalton Schaefer, the documented conviction is for aggravated burglary, violation of an order of protection, and aggravated domestic assault. From the documents received by the Commission, it appears the applicant received 2 Class C felonies and a Class A misdemeanor and was sentenced to 8 years of supervised probation on April 25, 2016. This application may be denied under TCA 5517-14A1C until April 25, 2029.
Hey, Mr. Schaefer, if you would, address us, please.
Yes, sir. Thank you guys for having me here today. Yes, I did get charged with those things that she had mentioned. It happened about 4 years ago. I was in a relationship with a woman and made a few poor decisions. I was young, immature. I made a few immature. Haven't really had any incidents since then. And I'd just like for y'all to grant me a license. I'm new to the car business in general. I did concrete pretty much my whole life, but I got into a car accident back in November and broke a few significant bones and decided to get into the car business. So.
Questions from the Commission?
Commissioner Vaughn, I have a few questions. You said that you had not been in trouble before.
I was in
had you?
trouble back when I was younger. I was 18 years old. I had a few misdemeanors, but I moved out of Florida and got away.
Have you had any issues since this conviction?
No, I have not.
Are you still with the female that?
No, I'm not.
In this?
No.
Other questions?
Mr. Jackson,
go ahead.
just one. Can you, the aggravated burglary?
Yes, sir.
Happened in 2015, I believe is what it says here. What was that about?
That was all one charge: the violation of the restraining order, the burglary, and the assault. Because I was living with the female that I was with, and anytime we'd get into an argument or anything, she would call the law, and then I would get arrested. What happened was I was living there, and we had gotten to an argument, and she had locked me out of the house. Well, I went elsewhere for about 4 or 5 hours to let her cool off, and it got to be nighttime, and I had work the next morning. She wouldn't let me in the house, so I pushed on the door, and it broke the deadbolt, and I left, and that's why they got me with that, because it was,
Burglary is like you took something that didn't belong to you. So they charge you for just
because there was a restraining order in effect. They charge you, like the aggravated assault wasn't technically aggravated, but because there was a restraining order out.
That you weren't supposed to be at the property.
Exactly.
Also, I'd just like to note that burglary is entering into the dwelling of another, so it doesn't have to contain an element of theft. It could be as much as putting your hand through someone's window. That's the entering of a dwelling. So
interesting. Didn't realize.
Wait, one
that.
more question. Was that a home or an apartment?
It was a home.
Home. Who name was on the home? Were your name?
She owned the home.
She owned the home. Okay.
Mr. Galvin, are you going through any counseling or anything? Any anger management programs? Or anything
They
like
put
that?
me into a batterers intervention classes that they made me take, and I've completed 17 of those classes. I've completed 4 years of probation with no issues. I paid off all my restitution, all my charges that that they make you pay when you know.
How long have you worked for Rusty Wallace Toyota?
I had worked with them for 3 months until they denied my license, and then I haven't been with them for about a month now, waiting for this meeting.
What makes you think that you could be a good salesperson with Rusty Wallace?
I'm great with people. I worked at a hotel for a while, front desk associate. I've had experience with customer service, so I always had an itch that I wanted to get into car sales. I just never really did it until I got injured and decided there's probably no possible way I'd be able to do construction. So I decided that was my opportunity.
Is there the person that filed the restraining order, was she injured in any way?
No, I grabbed her by the forearm to try to get my phone out of her hand, and they charged me.
Hospital?
Nope. She said it left a bruise, and that's what had happened.
Other questions? Let's hear from your sponsor or person you brought with you.
Thank you, guys. My name's Jimmy Campbell. I'm one of our managers up at Rusty Wallace Toyota. Ever since Dalton came to work for us, obviously we didn't know each other very well. He moved here from Florida, so he's new to the area. He got away from a lot of the bad, negative things in his life down there. So coming up here for him was kind of a way for him to get out of the situation that he's been used to. Ever since we've had him there, he's been a very hard worker. He shows up every day. He does his job. We like him on the sales floor. He sells cars. He's an asset to our company in that way. I've never had anything but positive encounters with him. Everybody has a past, just like we was talking about with the previous guy up here. I think everybody deserves a second chance. We've all been in situations that were, bad and could be twisted in a way that makes it look a lot worse on the individual. And I think that might have been something that could have happened here with Dalton. But like I said, he's done everything that he's supposed to do. He's paid up his restitution. He's trying to do his part. Like I said, he's been waiting a month just to come up to this meeting. We drove here from Morristown. We had to leave at 5 o'clock this morning just to get here. So I think that shows a little bit of initiative on his part. He's really trying to make this work and do something right with himself. So, I know it's in your guys' hands, but if you would allow him to, he would greatly appreciate it, and we would appreciate it having him there as a salesperson as well.
Thank you. Go ahead.
Mr. Schaefer's general manager is Greg Von Cannon, and he knew I was on the commission. He called me, and he said that he wanted me to tell the commission that he would be here today if he could, but Rusty Wallace changed his plans. That he thinks a lot of this man. He asked us if we'd give him a chance. So Greg's a good guy, and I think if he thinks that much of this man, I'm going to make a motion that we grant him his license.
Okay. Do we have a second?
Jackson seconded.
Any further discussion?
This is Commissioner Lee. What brought you from Florida to Morristown?
My family, they all migrated here. My grandparents moved here about 20 years ago, and then slowly, pretty much my whole family, lastly my parents moving here, and I stayed down there another, I think it was 6 months after everyone had moved up here, and then decided, the best thing to do would be to move up to Tennessee.
Mr. Gillum, would you call the roll?
Commissioner Levy?
Yes.
Commissioner White?
Yes.
Commissioner Melton?
Yes.
Commissioner Chebanian?
Yes.
Commissioner Lee?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Kramer?
Yes.
Commissioner Evans,
Yes.
Commissioner Tomaso,
Yes.
Chairman Roberts.
Yes.
Motion carries.
Okay. Okay, for the director's report, Mr. Gillum, would you present that?
Sir. Since the last commission meeting of July 2019, the following activity has occurred. We have opened, relocated 66 dealers. Our active licensee count as of October the 7th of 2019 is 3,681 dealers, 20 applications in process currently, 133 distributors manufacturers, 29 auctions, 533 representatives, 17,063 salespeople, 102 salespersons applications in process, and in the last quarter, we have approved 1,469 salespersons applications, 246 dismantler licenses, 39 RV dealers, 75 RV manufacturers, and 1 motor vehicle show permit. Our complaints opened from August to current date. The number of complaints opened is 143. The number of complaints that were closed, 123. Our final annual sales reports numbers: the vehicles reported sold in 2018 was 1,314,742. Recreational vehicles reported sold in 2018, 9,212. Our total online annual sales reports collected were 3,392. Our late annual sales reports collected 962, which generated revenue for the annual sales report collection at $96,200. Our performance metrics for the last quarter: our average number of days to license, we've done 1,529 applications in 3.86 days. The compliance is at 92.83% as of September 2019. Our customer satisfaction rating for the quarter was 99.3%. Our DAR report, and I believe that the report is on your iPads, the total collected from July to September was $38,750. And our online adoption across all professions, as Commissioner Lawrence said earlier, is at 83.33%. That's the online adoption for all 1010s or new applications across all professions. And that is as of October of 2019. And Chairman, that concludes the Director's report.
Well done, Mr. Gillum.
Thank you, sir.
All right, next, legal report. Oh, do we need to make a motion at this moment? Okay.
Commissioner Jackson, make a motion to adopt the director's report.
Second, Commissioner Vaughn.
Further discussion? I think we can just do a plural vote on this. All those in favor say aye.
Aye.
Opposed? Okay. Legal report from Erica Smith and Stuart Huffman.
Yes, we discussed the legal report and we made 2 changes to number 38, 2019-045861. So we are going to place that in a monitoring status specifically so we can investigate further into any evidence of violations, and then we can bring it back to be presented. And then on number 108, 2019-065541, we are assessing a $3,000 civil penalty, plus we are doing an inspection, a follow-up inspection in 30 days, and we will be keeping that open and monitoring it. And that concludes the changes. Everything else was approved.
We have to vote on each individual segment or to adopt it?
No, sir. Just adopt or make a motion with the changes that the Legal Review Committee expressed this morning.
Commissioner Jackson, make that motion with the changes to adopt the legal report.
Further discussion? All those in favor say aye.
Aye.
All those opposed? Okay.
I'm abstaining.
Okay. Okay, legislative updates. Maria Bush.
So this was what we were going to cover with Carter. So we've already handled that portion. So we're good to go. Thank you.
Committee reports, I don't believe there are any at this time. And new business, we're going to discuss meeting dates for 2020.
The proposed meeting dates I sent to you to the commission last Thursday, I believe. And I would just open it up to this body. If there are any conflicts with any of the dates that you've seen, just open that up for discussion.
Jason, I do have a couple. The April 21st through 22nd, if we could possibly do it the 28th or 29th, it would really help my schedule. And then the July 21st and 22nd, I'd love to change it to the week before, the 14th and 15th. Other than that, I don't have any conflicts. Anybody else?
April the 28th and 29th would be the change.
The second date, please.
July 14th through the 15th. Y'all still like meeting on Tuesdays and Wednesdays?
Absolutely.
Okay.
Yes, yes.
Okay.
No more Easter Sundays. at the
Way to go,
hotel.
Jason. Way to go.
You got a point, Jason.
Although we're discussing the dates, just a general discussion on the start time. Since I've been on this commission, I think Nashville's grown by a million, billion.
I think you might be right.
This is no longer a town that you can get into from out of town the day of in the morning without. But I understand most people are either here or maybe come in the night before because they're farther away.
Your suggestion is
10 o'clock start time to allow for people to get into town after the traffic has died down, considering our meetings typically are no more than an hour and a half or 2 hours. Obviously could be adjusted on days when if we had a lot more on the agenda that we would know. I don't know what the notice requirements are in terms of how far out we need to publicize the start time. But if everyone is fine with 9 o'clock and I'm the only one, I'll make do. Just wanted to raise the question.
And the legal would start at 9:30 under your proposal.
Yes, sir.
Living here, I mean, I'm not sure what that window is to move it to because it's pretty much gridlock up until 9 o'clock. So I don't know how you move it and improve it a whole lot.
Well, I mean, the moving it back an hour misses the bulk of it. It's still possible to get in. I've had no trouble getting into town for 10 o'clock meetings. You either get here at 7 in the morning or get here at 10 in the morning. That's really about the answer now.
That was going to be my suggestion. We can move it up. I know how we could avoid the traffic. You move it up to 7 a.m. You miss all the traffic. I promise. But I can't guarantee you after that.
I think we'll just stay at 9 a.m. is what I'm hearing. I'm just glad we had the discussion.
I'm just stating the obvious there. I mean, 9 o'clock doesn't change a whole lot. Yeah.
Being from Memphis, we're just jealous, so.
I'm flexible either way.
We can FaceTime,
9 a.m. it is.
Any other conflicts with the proposed dates?
One more. In April, it's the week after, and in July, it's the week before. Is that correct? Okay, thank you.
I'll send out an
do we need
updated
to-
sheet. I'm sorry.
I'm
Chairman.
sorry.
I'll
Go
send
ahead.
out an updated sheet for everyone.
Do we need to vote on this change?
Yes, sir.
Okay. Do we have a motion to approve the meeting dates?
So moved.
Second.
Those are base.
Any further discussion? All those in favor say aye.
Aye.
Opposed? Okay.
One question, Commissioner Jackson. You gonna send a little card out?
Yes, sir. We'll have those made again this year.
You ruined us with those.
Remember.
Send a little
Anything in
card.
old business? Do we have a motion to adjourn? Any further discussion? All those in favor say aye.
Aye.
All right, move through it.
It was worth a shot, right?